of the board. So good morning, everyone. My name is Violeta Moreno-Lax. I'm a professor of law here at Queen Mary University of London. I'm the director of the OrderS Centre. Welcome all very warmly to our inaugural lecture, marking the beginning of our year of activities and what we hope is going to become our flagship lecture series on the past, present, and future of borders and how law draws and interacts and designs these borders in different ways. We are very pleased and honored to have with us Professor Guy Goodwin-Gill. It doesn't really require an introduction, but for the sake of those online whom I'm not sure I know, let me anyways introduce him very warmly. He's an honorary professor in the Faculty of Law and Justice and the Calder Centre for International Refugee Law at UNSW in Sydney, Australia. He's also an emeritus fellow at All Souls College at the University of Oxford, where he also serves as emeritus professor of international refugee law and an honorary associate of the Refugee Studies Centre, also at the University of Oxford. Apart from a very influential and decisive academic in our field, who helped establish the foundations of today's international refugee law as we know it, he's also been a practicing barrister at Blackstone Chambers in London, and he's represented pro bono the Office of the High Commissioner for Refugees in different important cases as an intervener. He's also the founding editor of the International Journal of Refugee Law, and he served as editor-in-chief from 1989, so since the foundation of the journal until the year 2001. He's lectured and published in several areas of international law, including obviously international refugee law, but also on human rights, responsibility of states, statelessness, free and fair elections, child rights, child soldiers, and the law governing the movement of people between states, which is what occupies the centre. The fourth edition of his Refugee International Law that everybody will be familiar with has been just released. It's now co-authored with Professor Jane McAdam and Dr. Emma Dunlop by Oxford University Press. And as I said, we're very honored and pleased to have him here today to speak about protecting refugees without borders and the very intriguing and decisive principle of refuge in international refugee law. Without further ado, Professor Goodwin-Gill, the floor is yours. Thank you very much for being here today.
Thank you very much, Violeta. I'm delighted to be here and to take part in this occasion sponsored by OrderS. Borders, yes, borders are interesting. Historically, they have moved from the fluid to the hard and rigid, and now back to fluid again. And in my lifetime, I've experienced most of them, as probably many of you here have also. The concept of border protection originated, one should not be surprised to learn, in the United States, with the goal of defending or monitoring the border of the nation, especially to prevent illegal immigration. In 1875, however, the proposed railroad was said to do much towards solution of the Indian problem. We all know how that worked out. Border control through passports and visas really came into fashion during the First World War. It was continued enthusiastically by some, with regret by others in the years that followed. But at the same time, exceptions were always recognized, particularly for the refugee and stateless person. Although the question of admission was not addressed directly, it was agreed from the start, before any High Commissioner was even appointed, that a refugee should not be sent back, but on the contrary, they were to be assisted in settling in and finding work. What has happened since then? Over the past 20 or 30 years, the notion of border control has been effectively hijacked by ministers of the Interior, of Home Affairs, or more sinisterly, of Homeland Security. And national security has become their mantra, and the daily practice signifies lack of accountability, the denial of accountability, and a refusal to countenance objection, more like ministries of fear, I suggest. Two examples, one from the UK and one from Australia, illustrate how far we have sunk. The UK case, reported recently in The Guardian, involved a Nepalese student wrongfully detained at the UK border. He was accused of being a fake student after he landed at Manchester Airport, despite the fact he had a valid visa, proof of a university place, and paperwork showing he had paid the necessary fees. He was detained for 12 days and lost his place at the university because of late enrollment. As the Observer report indicates, his treatment underlined the fears about increasingly hostile treatment for international students. The Home Office was asked detailed questions about his case, but did not respond. The position consistent with its general refusal to deal with individual cases. Instead, a spokesperson said, I quote, "We have a crucial role in keeping the UK and citizens safe. Border Force's priority is to maintain a secure border, and we will not compromise on security." The Observer pointed out that he had never posed a security threat nor ever been identified with any threat to the UK. The spokesperson said, "Thank you for your questions. However, this is our statement." The second case involves an Afghan refugee who was on the point of being granted Australian citizenship after having arrived there in 2009. His application was cancelled at the last moment, and then his permanent residency was cancelled also. The case centred on his identity, because the Australian government does not generally recognise the validity of identity documents known as tazkiras. These documents are in fact notoriously inaccurate, subject to change, and they can contain incomplete or incorrect information due to no fault of the bearer. On the one hand, the Australian government insists that Afghan applicants for citizenship obtain such a document. On the other hand, they then have no difficulty finding fault with the documents so produced. Like the Home Office in the United Kingdom, the Australian Department of Home Affairs declined to comment on the case, in this instance citing privacy concerns. It claimed that all non-citizens in Australia must satisfy security requirements, among other criteria, and the department's cancellation powers ensure the protection of the Australian community and the integrity of Australia's border and visa programs. Each of these cases indicates a level of vindictiveness, I suggest, that is so easily avoidable. In the case of the Nepalese student, he was wrongfully detained at the border. Mistakes were clearly made by the Home Office, but they were clearly driven by the hostile environment initiated by Theresa May and buttressed by subsequent negative policies driven in part by the Brexit clamour for control of the borders. The Australian case was also driven by negative policies, in particular the years of the Stop the Boats programme and the programme of offshore processing, while the 1951 Convention, on the other hand, actually provided a remedy. At the 1951 conference, the United Kingdom government noted that provision for state authorities to provide documents that refugees could not provide for themselves was not necessary in the UK or other common law countries, where the affidavit could substitute. Frankly, it does not matter what the original identity of the refugee is, because as from the moment of naturalization, he or she becomes the person who is actually defined in the citizenship papers, and his or her photograph, fingerprints, and even DNA will now be on record. A concern, however, is reliance by both Australian and UK authorities on claims to be defending national security, where there was manifestly no evidence of risk. It's as if that was a recipe for no accountability, no obligation to explain or give substantive reasons for decisions. Why, one might ask, is national security not mitigated by other government departments having other government policies, such as attracting international students or promoting integration? In either case, no issue of national security arose other than what appears to be the simple administrative function of managing the border. So, what about the law? What about relevant international law? There is a lot of good law about. As I wrote in 1986, but then as now, the task is securing compliance. 1951 Convention and 1967 Protocol provide a standard for the protection of refugees, which ought to govern the approach of states parties. As is well known, these treaties take an individualized approach to the criterion of refugee status and its resulting benefits. This is a strength insofar as it recognizes the notion of individual rights, but a weakness also insofar as it fails to encompass less well-defined situations of need, such as famine, drought, war, trafficking, modern slavery, or civil strife. For these reasons, it was long recognized that the conventional protocol approach was inadequate to provide protection and required adjustment in the light of the realities of displacement and distress. Consequently, standards of response were cobbled together to deal with situations of mass involuntary movements. Looking back over the past 40 or so years, one can see these standards developing around one legal obligation in particular, the principle of non-refoulement, considered as operating through time. Non-refoulement today and tomorrow. Here, in the operational role of non-refoulement, the only valid question is that of risk to those in search of refuge. The UNHCR, the UN High Commissioner for Refugees, of course, has an international mandate to protect refugees and to seek solutions to the problem of refugees. And exercising its responsibilities, it has never been constrained by borders. Originally limited to those with a well-founded fear of persecution, like the Convention, UNHCR's mandate rapidly expanded. Already in 1976, the Economic and Social Council had recognized the importance of the essential humanitarian tasks undertaken by UNHCR in the context of what were called then man-made disasters, in addition to its original functions. And doctrinally, the General Assembly adopted the good offices approach as an umbrella concept under which to bring refugees who do not come or do not within the competence or immediate competence of the United Nations. In this developing area, the focus shifted from the subjective to objective factors, indicating that people were effectively without protection, that UNHCR also had protection responsibilities towards those often large groups of refugees. And this development found support at the regional level with the 1969 OAU Convention, the 1984 Cartagena Declaration on Refugees. Nor are such developments confined to particular regional initiatives either, but reflect, I suggest, a universal recognition of humanitarian obligations towards those in need, towards those who, by reason of circumstances beyond their choosing or control, lack or are denied the protection normally expected of their government. It might be argued that generosity in reception was just a matter of discretion, and that non-refoulement as an obligation was limited to the refugee defined in the Convention and the Protocol. Customary international law, however, has come to incorporate this core meaning and to extend the principle to include those in the broader category. Subsequent legal developments, providing for those at risk of torture, or who as children benefit from the best interest principle, or who are smuggled or trafficked, or who are at risk of disappearance, or who, as the European Court of Human Rights confirmed in lieu against Poland, are at risk to extradition, have all contributed to making non-refoulement the center of protection. They are all instances of simple acceptance of refuge. The principle of non-refoulement applies as soon as certain objective conditions occur. And where these exist, the burden of proof is shifted to the state, which would otherwise seek to deny entry or to expel those concerned. At the same time, it is nonetheless important, rhetorically and substantively, to maintain the distinction between non-refoulement and asylum, and consider certain related questions. For example, how are the beneficiaries of non-refoulement to be identified in a practical way, in terms of groups or on an individual case-by-case basis? Secondly, what rules of evidence or presumptions, if any, should govern the process of identification? And third, what is the extent of protection? That is, what rights should the refugee who is protected by non-refoulement enjoy in the course of that protection, such as access to employment, education, and family reunion? In practice, identifying those who benefit from non-refoulement should clearly, to my mind, be based upon a general policy of refuge, which protection is only ever denied in a limited number of exceptional cases. The disadvantages of a case-by-case approach lie, as we well know, in the demands it makes of national resources. In such circumstances, only too often the humanitarian goal of protection is lost in the process as backlogs build up and will then commonly instrumentalize to further penalize the refugee. In brief, the risks caused by aggression, civil disorder, domestic conflicts, or human rights violations generate a presumption of humanitarian need, rebuttable, I suggest, only by clear and convincing evidence establishing that the danger no longer exists. As Bill Ong-Hing noted in a recent piece in the University of San Francisco Law Review, the criterion for protection needs to be upended and eligibility for protection should be pursued. And there are lessons, of course, for us from recent events. In practice, the war in Ukraine has taught us lessons about what is possible. And we now know that refuge can be provided to large numbers of refugees. Ukraine has taught us this, as Syria, Afghanistan, and Iraq ought also to have told us in the past. Of course, there has been some resistance to the principle of non-refoulement through time. Many objections have been based on a traditional view, which sees asylum in the sense of a lasting, durable solution as the most appropriate response to refugee problems. States then see themselves as having a limited capacity to afford this privilege, thus built this far, to borrow the Swiss phrase from the Second World War, which they also characterize as potential threat to immigration control. But asylum, considered in the simple sense of protection, does not have to be viewed in this way. It is a mistake to make the leap from non-refoulement to asylum. For a start, differences in the flows of people resist facile generalization, such as the assumption of permanency. Compare, for example, the massive exodus from Venezuela and the massive exodus from Ukraine. What is needed, as just a seismic shift of attitude. States, and more particularly the public at large, need to understand and to recognize that the movement of peoples between states is not going to stop. Borders are effectively no control over such movements, and it is a big lie to pretend otherwise. Even Australia's Stop the Boats program had its deficiencies, and many refugees successfully arrived in Australia by other means. In the past, I've argued that Europe, and particularly the European Union, has special responsibilities given its assertion of an entitlement to monitor and control the movement of people across the Mediterranean. That responsibility and the complex of protection obligations that go with it arises because of a combination of context, circumstance, knowledge, and engagement. The legal interests of states of origin, transit, and intended or actual destination are all engaged. Only a rights-based approach is like to have an impact. In the years since 2016, however, the European Union and its neighbors proved to be a mess of dislocated, dysfunctional sovereign states. In Greece, Turkey, Hungary, Croatia, Serbia, and Belarus, among others, official approval was given to pushbacks, assaults, abandonment, and denial of access, all in order apparently to send a message to the refugee. But still they came, and still they come. The record numbers now crossing the channel and meeting a government that does not know what to do, other than to claim there is an invasion, the asylum system is broken, that Rwanda is the answer, all evidence the contrary notwithstanding, that somehow or other France and Europe must stop the boat. Brexit naturally plays a part in this chaos, but Dublin, with all its faults, provided for some returns at least. States want control of their borders, we're told. According to Boris Johnson, that's what people voted for when they voted for Brexit. But being in control is not the same as closing borders and pursuing arbitrary detention and arbitrary expulsion. Being in control means developing and maintaining legal migration channels and effective asylum procedures. It means subscribing to and committing to the rule of law and respect for fundamental rights. What the public wants and needs is not closed borders, but confidence in government that they can manage migration in all its aspects. But what we see everywhere is evidence of failure. The so-called backlog of undecided cases, now in excess of 100,000 in the UK, is the fault of a government. In fact, the fault of conscious political decision not to allocate funds or other resources. A government that was unwilling to look further ahead than its own nose or prepare for what was certainly to come. A government which is also contemptuous of rights and the rule of law. The MOU, the Memorandum of Understanding with Rwanda, will solve nothing, but instead will visit hardship on a limited number of individuals, as was the case with so-called offshore processing in Australia. Nor has it long been recognized as the solution to refugee problems the sole responsibility of individual states. Solutions, of course, depend upon cooperation. All states should cooperate together with the United Nations to relieve states receiving people in distress. In addition, states should cooperate in accordance with the principles of international solidarity, burden sharing, and promote solutions through local integration or resettlement for people in distress who are unable or unwilling to return to their country, while also contributing to, for example, climate adaptation in states threatened by sea level rise as a result of climate change. The protection of those in flight is a paramount obligation. It's a duty that transcends borders as well as formal categories. Formal categories such as status as a refugee, status as a stateless person, or beneficiary of complementary protection, or someone entitled to humanitarian consideration, or someone deemed excluded for reasons of criminality or national security, or someone otherwise extraditable, or one who is trafficked or a victim of modern slavery, or one who flees famine or drought. The humanitarian necessity is always there. And one of the questions we have to ask ourselves as the movements of people continue to grow are the extent to which a principle of refuge has normative force, and how, in any event, are we to galvanize and operationalize the necessary political will so that no more lives are lost and that futures can be rebuilt. In a 2021 Harold Bond lecture, Tendai Ichumi noted that much of the analysis of responsibility sharing is informed and constrained by the doctrine of sovereignty in international law, according to which obligations are derived from consent. In addition, there is little challenge, she wrote, to the legitimacy of the political and territorial borders that states use to justify differential treatment and exclusion. She argues for Asylum's reparations for past injustice, but rather than seeking compliance judicially, she sees popular social movements, her term, as the vehicle for change, for mobilizing different politics for pressure on imperial states to curb intervention and domination. Asha Walia, in her recent book, Borders and Rules, Global Migration, Capitalism and the Rise of Racist Nationalism, makes a similar point, that mass migration is the outcome of the actual crises of capitalism, conquest, and climate change. The borders today are bound up with the violence of dispossession and exploitation. But what justice demands, what politics can produce, are often very different. For example, the problem with climate change, as Camille Parmesan has said, is that there is no end in sight. We knew when the climate would stabilize, we could prepare for that. We must therefore start thinking and preparing now for what is inevitable, a crisis that is not made by those who are most deeply affected. Here, I think international law can provide a framework for thinking and action. I see non-refoulement through time as a critical component of the principle of refuge, though I agree that solutions are not to be found solely through legal action, by expanding legal exceptions to the enforcement of borders or pushing the enforcement of existing exceptions found in international refugee law. The core issue is and must always be protection. And whether we talk of the refugee in a narrow or broad sense, or speak to those who are trafficked, or increasingly those compelled to flee by climate change or weather-induced events, protection must be at the forefront of our minds. And protection is due no matter where the call is made, in maritime areas, in state territory, spaces between borders, border fences, and border guards. Yes, international responsibility follows the state, or to be more precise, it leads and goes ahead. Protection is not something to be tacked on as an afterthought to some legislative proposal to curb this or manage that. No, it's a paramount consideration, and if needs be, it must be fought for also in the courts. What use, though, is a general principle of refuge and customary international law if compliance is not there? What if there is no political will? The political will is widely argued is essential if an effective policy with regard to managed migration and refugee protection is to be introduced. How, anyway, is political will to be defined? Where do you get it? How do you mobilize? In the present context, a context which units ourselves, there are 100 million forcibly displaced, including 14.4 million as a result of conflict or violence, and a further 23.7 million as a result of weather or climate events. This present context, political will can be said to involve a sustained commitment over time of key state and international organization decision makers to deal with numbers on the move and to improve their situation through the development, implementation, resourcing, enforcement, and monitoring of legislative policy and practical processes. But it goes beyond rhetoric to require action. What we know is that political will cannot be imposed from outside. Quotas just do not work. In addition, commitment and support must come also from the public and non-state actors, a whole of societal approach. Above all, there needs to be recognition of the issues, not a head in the sand approach and misguided belief in the capacity of borders if managed effectively to stop the movement of people. Funding and monitoring are clearly also required. Finally, Frontex was revealed as having engaged in the non-reporting of serious incidents contrary to international human law, but not having suspended operations, but having withheld operational information, even from its own fundamental rights office. Monitoring can work change. Politicians on the right use the fear of people crossing borders to strengthen control, but to what end or purpose? This is once again, the big lie. The crisis of displacement in and from the Ukraine demonstrates what can be achieved if the right political decisions are taken, if inclusion is available from day one. There's been no meltdown. Access to protection is advantageous for states, as it also is for those concerned, and even onward movement does not bring the sky crashing down. Differences in the composition of flows may call for differences in strategy, but do not justify discriminatory treatment. Its resolutions adopted on Ukraine in March and October, the General Assembly demanded that all parties allow safe and unfettered passage to destinations outside of Ukraine. That they protect civilians fleeing armed conflict and violence, including foreign nationals, notably students, without discrimination, and allow voluntary, safe, and unhindered passage. They strictly respect international humanitarian law, international human rights law, international refugee law, including the principle of non-refoulement. The General Assembly called for full funding of the UN's Humanitarian Response Plan 2022, the flash appeal for humanitarian response in Ukraine, and the regional refugee response plan for Ukraine and its neighboring countries. At the same time, went on to express its deep appreciation of significant parallel efforts that have been made by neighboring countries to accommodate refugees. Significantly, the General Assembly expressly recognized the link between armed conflict and violence and conflict-inducing food insecurity. It stressed that armed conflict, violation of international law, and food insecurity can be drivers of forced displacement, and forced displacement and armed conflict have a devastating impact on agricultural production and livelihoods. Most recently, in November, the General Assembly reiterated that Russia must be held to account for violations of international law in and against Ukraine, including its aggression and violation of the UN Charter, and it should be responsible also for legal consequences of all its international wrongful acts, including making reparation for injury. Together with COP27, perhaps we are at a moment when political will should be captured. It is time for change. I've argued in the past for institutional reform and for a revised statute for UNHCR to recognize the changes in the international scene since 1950 and to enable UNHCR to prepare for what's to come, be ready to provide protection for the broader class of refugees, the stateless, and those who, displaced by climate change, among others, do not have the protection of their own government. I know that has not found traction with UNHCR itself, which tends to be wary of any formal measures to increase its mandate. But I think this is the time to revisit this issue and to argue for change. There's ample room too to further strengthen the office of the UN High Commissioner for Human Rights, which is doing great work in reminding states their obligations in regard to border management and providing practical guidance. There's also scope, and I would argue that is in fact crucial in a whole of society approach in galvanizing political will and effecting change, the sort of inquiry and research being conducted by OrderS, the Center for the Legal Study of Borders and Migration, and other centers similarly situated. What is being done in our name, and of course our pounds, our euros, our dollars, needs to be more widely known and understood. Organizations in Europe, Australia, and the United States, among others, have illustrated in ways that have influenced public opinion, no doubt about that, how the lives of men, women, and children have been impacted by government policy and indifference. They've shown time and again the physical and psychological damage caused when refugees are detained in inhuman conditions, when they are pushed back, when they're denied access to territory and procedures, and their lives are often lost in interstate squabbles about disembarkation, or whose protections denied and unseemly debates on external invitation. Non-governmental organizations such as Situ can assist in identifying instances of those responsible, which is particularly important for those of us that engage in research. While ECRE and Statewatch advance transparency and keep us up to date on policy and legislative development. Other measures, particularly parliamentary oversight committees, have followed the money as best they can, when funds are allocated to state or private sector bodies charged with administration of public functions. There is a lot of corruption out there. At the same time, lawyers and paralegals argue for protection in dozens of courts and tribunals throughout the world. I suggested in my title, the protection of refugees, but without borders. I recognize, of course, the reality of the border and the power that states exercise there, but they exercise no less power extraterritorially, and it is these that must be called to account. In doing so, we can rely on an epistemic community of like-minded individuals and communities, who are learning by cooperating in the protection agenda and strategic litigation and policy advocacy. What is needed all the time is this deep analysis and integration of results into the broader policy debate. We show clearly the need, the humanitarian need, of individuals in search of refuge, for a reframing of the border wherever the state exercises authority and control, away from its present arbitrary focus on national security and towards international protection. In this way, the Center that is Borders will live up to its mission. Thank you.
So thank you very much. It's time for questions. We can have a first round for those here in the room, and those online, if you could type your questions and we will pick them up from the chat. That would be great. Okay, so I have already one question.
I'll start to break the ice, and everybody else, I'm sure, is going to pile in with questions. After the first one, Guy, that was a terrific speech and very interesting one. There's one thing that you didn't comment upon, which is the necessity of borders for refugees, that they only exist because there are borders.
Yeah.
But I wanted to ask you to develop a little bit further on this political will issue. And we've been talking about this for the better part of 40 years, and it seems to come and go. I wondered whether you could give us some reflections on how political will gets disaggregated. Because you've mentioned, well, you know, we have somehow a really hardcore in some interior ministries, where the use of the idea of national security has transformed the refugee into some kind of enemy, which our ministries of defense say, oh no, the whole channel crossing business, when the Home Office tried to get Ministry of Defense to step in, they said, no, this is not an enemy. And I wondered whether you could give us some reflections on how do we disaggregate political will in order to reframe it and turn it into a more productive force for refugees?
Yeah, I think that's a very interesting question. That on the issue of borders being relevant for refugees, I agree. It's something I can mention. The fact of crossing the international frontier triggers international law. It's not the only trigger of international law, because internally displaced people are also subject to international law, entitled to a certain measure of protection, which is difficult to expect. But coming to your basic question, this academic will, I think we have internally, I've come to this sad conclusion over many years, that there is a war in government between ministers of fear, ministers of interior and home affairs, and everyone else. They have arrogated themselves control for a large part of the issues of refugees and asylum, and everyone else seems to ignore all that. And I think that's got to be combated. I think the way to do that is through public pressure. I think by bringing to most of the public the treatment, the actual treatment of those in search of refuge, such as we've seen in Marsden and elsewhere, will do wonders to I think put pressure on. Of course, it has to admit that the government in question is not inclined to respond to such pressure, but it's nonetheless to maintain that the pressure through knowledge and inquiry. I think that's one important thing. From the broader perspective, the international perspective, I think we have to recognize and we have to encourage those who are more knowledgeable than I am in this area that the numbers are going to increase. And the changing socio-political reality of people arriving is going to have an impact on each of our countries. And we need to be prepared for that. And prepared, I don't mean by arming ourselves, but by putting in place provision for assistance and refuge assistance to those who arrive. And that's why I think there is time for reconsidering the notion of refugee status, which is highly individualized and just, it seems to me, not really suited to the sorts of problems that we have today. And that also has to be faced up to. And I think, again, we need to highlight the personal stories of individuals who are in need of refuge at the present time, who don't satisfy the real kind of fear of persecution, but who nonetheless have good reasons for seeking refuge amongst us. For example, those who cannot work because you cannot work outside of 45-degree temperatures, and you cannot eat, therefore you have to move. That is so obvious that it's the story that needs to be brought home, I think. So I think the whole political will, this is an area which I'm relatively new, I don't know enough about how to get it working. But I think those elements which we can see, which I mentioned, which are the facts, the changing socio-political reality is going to come in. And it's one of the things that could galvanize the public and therefore by extension by governments as well to do something behind them.
Thank you. I'm sorry that I'm sort of like keeping up and down and all of that. It's just because the microphone is there. We need to project our voices in that direction if everybody could. I have a question from the chat. It's actually from Ruby Ziegler. In the UK, a Tory MP, Tim Lawton, has recently exposed his party's Home Secretary's empty rhetoric regarding the existence of safe and legal routes, highlighting the inability to arrive in the UK legally to seek asylum, except for arrangements for specific nationalities like Ukrainians. So there seems to be more political support for instituting an out-of-country humanitarian visa application process. And he wonders whether you could speak to the promises and challenges of such a regime were it to ever be instituted.
Well, that's a nice question too, Ruby. Thank you very much. Yeah, it's always been, I've always been amused by the fact that you always said there's no refugee, there's no asylum visa. You can't get a visa to claim asylum in the UK. And that was held against you. Because if you came as a student or as a business person and said, actually, I want to claim asylum, they'd say, well, you should have applied for asylum visa. There was no asylum visa. That was held against you and used to damage your credibility. I think it's high time that we had an asylum visa equivalent, a pathway, a legal pathway to protection. I think that could be integrated into a resettlement program as well. And we could see it moving in the right sort of direction for individuals who are in a position, there always be a select few individuals, of applying for a visa and seeking asylum in the UK, or through applying for a resettlement opportunity. That it could be, there are no legal channels at the moment apart from the Ukraine. Each time we have that.
Perfect, thank you again. I have three questions from the room. So maybe you could introduce yourselves. So please go ahead.
Yes, I'm Carol Boner, and I would be interested in whether you see this asylum visa as something different from the resettlement programs that other countries, US, Australia, New Zealand, and the Scandinavian countries, who do it through the UNHCR. Are you suggesting something different?
No, additional to the resettlement programs.
Mhm.
So I have another question here and then Sarah.
Yeah, hi, I'm Tamara. I'm an LSE fellow. I'm from Australia. My question is related to sort of the question around political will and how you sort of conceptualize it. And you talk a lot about sort of government responding maybe to this mobilization of the public. I'm just interested in the conception of government here and whether this can also be disaggregated, because you obviously have the political element and political leaders who are obviously interested in election and being re-elected. But I also wonder how this political will sort of will translate to, you know, the bureaucracy and civil servants and those advising governments. There was a recent sort of article where the Home Office had produced a report that demonstrated that pushbacks was not an effective policy, and the government seemed to, the higher echelons of government decided not to listen to this. And I just wonder how we can sort of create, I don't know, better translation of this evidence and, you know, political interests, like through the bureaucracy and then back to government as well. So there's that added element to it. And I don't know if that's in place in your conceptualization.
Yeah, I think I get the impression that within government, within the Home Office, there is a lot of fear regarding talking about alternatives, but regarding talking about the report you mentioned. Fear of crossing the line, upsetting a minister or whomever. And I think that's what we overcome. We overcome by publicising this report as widely as possible and getting it possible Home Office officials to endorse the publication, to recognise that pushback and not going to work, and we need to think of something else. But to pretend that they are going to work is not the big lie. I'm afraid the government and the Home Office in particular has endorsed the big lie in many respects. The assumption that borders will stop, effective control of borders will stop people coming. It won't. It never has done. So I think that's one aspect of Home Office whistleblowers, if you like, to take the stand and to recognise the value of this report, and we think that it's become the future debate.
Thank you. Sarah.
Thanks. I'm Sarah Singer. I think my question sort of follows on from that point a bit as well. Because something alongside all of the awfulness that's been happening in the UK over the past year or so that I find quite heartening is that you've seen Home Office staff making a stand themselves and being involved in legal challenges against some of the Home Office policies for their unions, etc. I think that's fantastic. But alongside that, we've seen increasing privatisation of Home Office functions in, you know, use of private organisations such as G4S, etc. And this, I think, creates an additional challenge in terms of the conduct of these operations and the ways that we can hold those organisations directly accountable. And I'd be really interested to hear kind of your thoughts on ways that we could counter increasing privatisation in this field in particular.
Yeah, I'm saddened by the extent of privatisation of this and other areas as well. There's no doubt in my mind that the Home Office, when it contracts out certain activities, remains responsible. And it's not, in fact, cases which are upheld with responsibility in medical matters for by those contracted to provide services. It's right for corruption too. We've seen this in Australia with companies receiving billions of dollars to provide so-called services in Nauru and on Papua New Guinea when they're still available. And it's been difficult to identify what's going on because in Australia, the government basically takes a web of secrecy over the budget. So it's impossible to know exactly how much money went here or there, and so on and so forth. I think that needs to be countered by an effective opposition. I think that's something that is important, to follow the money and find out what's going, and to identify those who are responsible for, say the ill treatment in detention centres. There was a brochure published 2 or 3 years ago highlighting individuals who have successfully resisted prosecution for assisting asylum seekers and refugees in Europe, identifying them and knowing their names and so on and so forth. I think we need to do the reverse. We need to identify those individuals who are responsible for ill treatment. And we need to know that we are living next to someone who abuses asylum seekers or who has given the say-so to particular policies. We need to identify names, and I think that's part of accountability. We need to go down that path as well. Now, I resist. I mean, it's well established. This commercial confidentiality approach. Oh, we can't say this because it would put the company at risk of losing business and restricting. I think that's absurd. I think anyone who wants to do business with the government has a duty to provide all information. But that's not, unfortunately, the case at the present time. I think it's something that's worth going for.
So 2 questions from the chat. One by Marie-Laure Basilien-Gange, who asks, what can we do as academics to promote new narratives regarding migration policy and refugee protection, and to reformulate sovereignty in a more positive light, so as to guarantee international obligations and human rights? She comments that we conduct research projects, lead research centers, intervene in the media, and yet we seem to be inaudible in national institutions and European organizations. I suppose that is transportable worldwide, and so your thoughts on this would be very much cherished.
I think, again, it's important that we carry on doing the work. I mean, presenting the stories of those who are impacted by these policies is important, and not in global terms, but in specific cases of this individual, this child, this mother, this man, who are impacted by the effects of policies, who are maybe killed, who are maybe abused or beaten up. I think it's important not to reduce their ill treatment to a systemic approach, but to identify 1 or 2 individuals who have suffered as a result of the policies and practices of the government. So yes, you may feel that you are invisible. But I think over time, we saw this in Australia. We saw this in Australia quite definitely. But over time, these reports of the mental trauma faced by those detained in Nauru filtered through. Doctors took a particularly strong stand on this. When refugees were evacuated from Nauru for medical treatment, doctors refused to allow them to be sent back to Nauru because of their condition that made it deteriorate further. That sort of approach can be very helpful, I think, and that galvanized a large measure of the public to support refugees. There's a great deal of support in Australia for refugees, and the more they learn about conditions of detention in Nauru and Papua New Guinea, the stronger that support came. There has been, the change in government hasn't led to a great change in policy, but bit by bit, there are changes going ahead there, which I think they're in no small measure due to the sorts of activities of NGOs and other groups who identify what's going on and what's going on.
Thank you. So the next question from the chat is from Nikos Trimiotis, and he asks, what can be done legally about the routinized practices that normalize pushbacks, particularly in Greece, in Italy, Malta, Cyprus, and in other places around the world? So we've seen in the Greek example, the head of Frontex resigning, but then the practice continuing without consequences. So what would be an idea for something that can be done so that these routinized practices can be stopped?
Well, my understanding is there is a legal process with Frontex in Luxembourg, but that's one avenue of attack. I think, again, one just has to continue going on. And just as the government in Greece is determined to penalize, criminalize, so we must make efforts to ensure that the government itself is held accountable. wherever forum we can find, whether the European Court of Human Rights or the Court in Luxembourg. I'm afraid it's more of the same. Keep fighting.
Okay. Questions from the room, maybe?
Can I just make a comment? Sorry, I just
Sure,
wanted
go
in
ahead.
response to like what academics can do, and as you were sort of saying in the Australian context, you see sort of doctors, reading this and then mobilising in one of the recent elections. I think you sort of do see that in the sense that the Labour Party sort of hesitated to be drawn into this politics and borders again, as it was in the 2012 election. So I do see that sort of change as well as they're sort of responding to maybe perhaps a liberal view developing among people. So I think definitely there's that sort of element to it. And I'm not sure how far they'll go with sort of, changing the temporary protection visas that we have, and whether they'll sort of make that a bit more permanent. But you can sort of see this attempt to reduce the hostile environment that we have. And I'm sort of hoping that that is a bit of a response to the academic activism, because it's huge in Australia, this academic activism.
Yeah. I think the government is playing it quite cannily. It's sort of generating reports of public support and then tinkering with the TPV, the temporary protection visa program. I think it's playing it. I'd like to see it move faster, but he's doing it quite cannily.
I have another question from the chat, from Ellen Alby, which is one of our PhD researchers here at Queen Mary. And she's currently undertaking her empirical research on Samos in the hotspots in Greece. She mentions that you have spoken a lot about ensuring a basis of humanitarianism for people on the move. And she's curious about your thoughts on the risks overly emphasizing humanitarianism to the European border spaces. In particular, here in the hotspots, we observe that humanitarianism translates into state and authorities simply negotiating bare minimum material and legal protection for people on the move. So what are the dangers of this humanitarianism speak and humanitarianism approach to refugee protection?
Well, humanitarianism is at the beginning, it's not the end of the matter. I think there are rights that need to be emphasized and need to be protected. And the minimum very often will not be up to the international standards. And that's the basis of
Somebody else is going to ask a question. I don't know how long you want us to keep going. And
We do have 15 more minutes until lunch comes.
okay. Then I'll ask another question. Guy, I'm a little bit surprised that you haven't made any reference to the new regionalism and the reinforced commitment of the African Union, for instance, to implement its 2018 protocol, etc., and transform areas from ones within which the Refugee Convention is very important to ones where it is less so. So I wondered whether you wanted to comment on that.
No. No, I didn't hear it, but you're right. There's a lot to be said there. And the experiments in Africa have actually lessons for us as well, particularly on free movement and other things. And in fact, to some extent, disregarding the protection where it's not necessary, as we could have done in Europe had we gone for a European status of refugee, recognize the rights of refugees in the country they wish to go to, as opposed to constraining refugees that make an application for asylum. As we've seen, work with Ukraine, so why couldn't it work with anyone else? And I think there is room for stepping out beyond the conventional box, as it were, and incorporating wider standards of wider protection standards towards refugees. So I think we should keep an eye on what can happen and see what we can learn.
Before I give you the floor, just to have a bit of an interaction with the chat. So Jasper van Berkel-Smith from the University of Amsterdam would like to ask you, what is the potential of Article 16 of the ICCPR, the right to be recognized as persons before the law, or the right to have rights in Arendtian terminology, in this context, as asylum seekers and migrants these days find themselves increasingly in a situation of rightlessness, this is an intriguing argument recently posited by Delphine Roderick, and he would like to have your thoughts on that.
Yeah, Delphine Roderick wrote an interesting, very interesting paper, which won the American Society of International Law's essay prize on the right to identity. And this is, ironically, this was one of the key issues that was identified by the UN in 1950 as which needed to be addressed in the context of the Refugee Convention, the right to dignity and the right to identity. I think what we see, this is even more necessary today. And I think that that's something which needs to be emphasized. I think under ICCPR and under the 51 Convention, we need to be sensitive to the idea that refugees are being denied identity. We saw this in Australia again when names were abandoned for the use of administrators and boat numbers were replaced. That's outrageous, and I think it was something to change. But it's the sort of depersonalization of individuals which goes on too often, and I think that it needs to be attacked as a violation of human rights. Depersonalization is too often the precursor to human rights treatment.
Thank you. There was another question by Sarah.
It's sort of a comment and a question in a way. So there's been some talk about Ukraine sort of as an example of what can be done when you have large movements of people. And I think we all know that the reason that Europe responded the way it did to Ukraine was because Ukrainians had pre-existing right of entry into Europe and free movement around. And so it strikes me that the way to have a similar approach to moving to other countries is to have free movement arrangements in place in normal times, which can then be harnessed to protect people. And I think that that could be really beneficial for certain circumstances, but it's not going to happen in the case of regions that are subject to large-scale kind of disruption, conflict, or indeed climate or environmental disasters. So I think that the Ukraine example is probably useful to a certain extent, but not completely. And I think the other thing to point out about the Ukraine example is obviously Europe has granted Ukrainians a temporary form of protection. So we do need to keep an eye on that and make sure that when temporary protection finishes or comes to a close, that we are prevented from accessing the full range of protection.
Yeah, I agree with you absolutely. I mean, Ukraine is Ukraine, and it's a very special place. It nonetheless does have lessons for us. I think it can show what will be numbers we shouldn't be afraid of. That's important. I think we need to recall that each time that we have a crisis. I think also I agree with you that one can't have three provisions in place for every situation of crisis. But at the same time, at the same time, I think also, oh, I'm sorry, I lost my thread. Remind me where I was going.
Example of non-example, the Ukrainian case.
Hmm?
If the Ukrainian case can serve as an example.
Yes, yes, that's something.
Okay.
Sorry, I got really lost.
Well, you gather your thoughts. I'll have, if I can abuse my own position, one conceptual question, because obviously you've been presenting the principle of refuge as the other side of the coin of the principle of non-refoulement, and I was wondering whether, apart from the presumption of humanitarian need in the circumstances that you've been enumerating, do you think that those circumstances imply a right to receive protection, and what would be the caveats, the conditions, or the limitations that could be attached to that? I mean, how would you conceptualize that right to receive protection under the principle of refuge?
I think I'd start with the principle, yes, that there is a right to receive protection.
Perfect.
But I wouldn't like to see it judicialized to the extent that the right to receive refugee status become judicialized in most countries, where it's become legalized and become the cause of the wrong decision-making processes. I would like to see sort of in code, like a right nonetheless, which we can talk about, but which we can see implemented, which should stay out of the courts as far as that's always been the other case, where someone insists they have a right, they should seek it.
to lose that right to receive protection. Very good. Any further questions before we break for lunch? From the room or from the chat? I have another one actually. Yes, sorry. It's dual channel of communication. It's a bit
I'm impressed.
hard to keep up. So there is one from the chat. And the question is, how do you see the future of the international refugee law system, given that we are likely to see mass post-migration due to environmental disasters and other issues? The projections, even the most favorable ones, will mean massive increases in flows and possibly in the billions. Will we need to abandon the individual approach in favor of a collective and non-individualized approach?
I tend to think that we are close to having to abandon that. We're not going to for many reasons, because many states see it as useful device for proving to the public that they are in control of their borders. No one gets anything set on an individual case-by-case assessment, and so on. But I think in practice, the numbers are going to be such we're going to have to admit that there are other options, other possibilities to explore. I think the numbers are going to be very telling. Now, if we want to avoid people being killed, that's the other option, which I'm afraid the states are probably considering about attacking those who are on the borders. And we have to encourage states to recognize that the problem is solvable cooperatively. States working together can come up with a solution. Now, in climate change, I mean, it's not only a question of dealing with those who must move, it's a question of providing alternatives to those who don't want to move. And therefore contribute to kind of adaptation, which I think is beginning to take off about. But I think COP27 current approach, I think that's something which we should consider as a whole society approach, which covers not only those who must move, but those who do not want to move, want to move within their country. I think that's something we should actually.
Can I have another question on that? Nobody else is. Do you think, speak up, on this question of climate change and refugees, do you think that our strategy in respect of trying to protect people who will be in need of international protection should be what was done in respect of the Convention on Enforced Disappearances, to argue for the inclusion in the next convention there will be on climate change for provisional non-refoulement? Do you think that would be an effective? I mean, it was used for the Torture Convention, it's used for the Convention Against Enforced Disappearances. Is this the way to go on climate?
I think it is necessarily. If we're talking, the principle of refuge necessarily accommodates those who are compelled to flee by weather-induced events or climate change. And they need refuge, they need protection in that refuge as well. Now, that the degree of protection may vary depending on the capacity of the state to protect them anyway. But I think that protection through refuge is essential.
So something that we as refugee academics should be starting to promote, that there needs to be an Article 3 or an Article 16 in the next convention.
Yes, I think it's going to need careful tinkering, because I mean, you're going to have states that are competent in principle of protecting their citizens, who are nonetheless compelled to flee. So you've got a possibility of joint protection in some ways, protection by the state of refuge, protection by the state of nationality. Something you don't have in a traditional refugee situation where the state of origin is the enemy, as it were, and is not expected to provide any protection and resist when they try to exercise protection. But in the context of climate change, the situation becomes fuzzy. They have, I think, states which are competent, but in principle to provide protection, but they're not able to do so for all sorts of economic and political reasons.
Thank you. I've just announced that this is our last round of questions. To people on the chat, obviously for those in the room, if you would have any final comments, questions, this would be our opportunity before we break for lunch. Yes, please, go ahead.
Thank you so much. I'm Isabella. I'm a student at LSE. You talked a lot about how you can galvanize public support and how this can change in relation to an institutional level. But I'm just curious how you think you balance highlighting individual stories with the fact that when you start to highlight these stories, these can also exceptionalize migrants, and that can lead to more of an argument of, okay, well, people need to have some struggle or they need to overcome some obstacles in order to have rights. So I'm curious on how you balance those two.
No, I don't have the answer to that question. It's a difficult one to focus on the individual while protecting the individual. I wrote a book, a book on child soldiers many years ago. And we used photographs of child soldiers. And that was before I thought my notes, that was not the right thing to do. And it's true. We can identify the facts of individual cases, but how far do we go and identify the individual cases? It's a difficult one to find a balance.
And unless there is, yes, please.
One more, not science, pastor in trading touch. I recently read a suggestion of giving the UK.
Can you speak up? Because the
Of course, yeah, sorry.
Yeah.
I recently read a suggestion that because of the very high rate of acceptance of some nationalities as refugees in the UK, we should move to a system of presumptive refugee grants. Because if we're giving 90% refugee status to people from Eritrea or whatever, why not go the whole hog and grant and just automatically grant it, thereby disposing of the backlog, subject only to national security. Any views on that as well?
Yeah, I think it makes a lot of sense. I really do. Although I have, in past days, I've run a lot of resistance on the part of government. In Canada, for example, in the 1990s, 80s, late 80s, 90s, we were having a lot of applicants from Sri Lanka and Central America who were going through a 93% success rate. So I suggested, well, why don't you just presumptively determine to be refugees? No, can't do that. We've got to have an individual case decision in each and every case. Why? Because that allows us to say to the public at large, don't worry, public at large, everyone who's recognized as a refugee has been determined on their individual facts to be a refugee. We managed to get agreement on batching cases. So we put 10 cases together before the Immigration Refugee Board, or 12 cases together, and they go through quite quickly. That has been abandoned now, but and there's still the problem of what to do with those who are manifestly well-founded. And Canada hasn't resolved that problem. The Immigration Refugee Board, which still exists, needs reforming in that regard in relation to its approach. I think what the approach that Bill Hong Ying proposed was that you upend criteria of asylum and you presumptively determine that people are refugees, and only exception deny them refugee status if, for example, there's clear evidence of persecution of others. I think it's the way to go. It would deal with the backlog issue. But again, the question is the decision makers. Well, it's the job of decision makers and one stuff, but also policy makers. Are they prepared to go that far? I'm not sure. They need to. I think the numbers may finally tell the tale.
Okay, and I have a final question from the chat, and please we will thank you and close. And it goes like this: can denial to grant humanitarian visas by an embassy abroad be recognized as an exercise of jurisdiction by the same state? This is a question by Carola Ricci. And I'd like to add, if possible, if this is so in your view, considering that the point has already been denied by the European Court of Human Rights in MN versus Belgium, but if this is so, because the court can be wrong, would the same reasoning be applicable to resettlement decisions, and what can be the consequences then? Thank you.
Yeah, I used to believe that it was not subject to judicial review. Now I'm more critical on this issue. But I still have difficulty accepting that the idea of judicial review because of the numbers of the resources, so forth. So, I mean, you're saying the European Court of Human Rights can be wrong. I remember a question of the Human Rights Court mentioning that we're not wrong. We just disagree with our decision. I'm not sure. It's an issue which I can't answer. I'm afraid I'm going to opt out on that one. I have sympathy for the claimant in that case. But I'm not sure that judicial review, the judicially enforceable right to the decision to provide protection was an appropriate answer.
Okay. All right, and on that note, I'm going to thank everybody in the room and in the chat, and I would like to have a round of applause to thank very much. There will be a recording available on the webpage of the event on the QM Plus website, on the QMary website, and thank you all very much for coming today. Lunch is served.